those who are free, all the staff members are requested to join in the meeting. Seminar. Telundu cheppalate seminar lo join avvandi andaru chepp. One, 2, 3, 4 వస్తూ పోతున్నారు. వెబినార్ ఇంటలెక్చువల్ ప్రాపర్టీ రైట్స్. స్టార్ట్ చేద్దామా? ఓకే 22 మంది వచ్చారు. ఓకే మేడం. Very good morning to all. On behalf of the Department of Commerce, JMJ College for Women Autonomous Tenali, I, Dr. R. Nagajyoti, lecturer in Commerce, is delighted to welcome you all to this two-day national webinar on intellectual property rights. Before going to start the webinar, let us invoke the God blessings by this prayer. Your spirit is here. Your spirit is moving. Your spirit is touching. Your spirit is healing. Your spirit is here. Again, a very good morning to all. May I request all the participants to unmute your audios, please. Thank you. I feel it a great privilege to welcome Dr. Sister Terisamma Gade, the correspondent of JMJ College for Women Autonomous Tenali, Dr. Sister Saini, the principal, invited speakers, Professor M. Venkateswarlu from Sri Venkateswara University, Tirupati, Mrs. M. Jyoti Gayatri Vidyapatham College, Visakhapatnam, and Dr. S.K. Kamaruddin from Maulana Azad National Urdu University, Hyderabad, and all the participants across the nation for this two-day national webinar on intellectual property rights organized by the Department of Commerce with the support of IQAC, JMJ College for Women Autonomous Tenali. Now, I respectfully invite Dr. Sister Terisamma Gade, the correspondent of JMJ College for Women Autonomous Tenali, to greet the gathering.
Good morning to everyone. On behalf of JMJ College for Women, Tenali, I cordially welcome you all to participate in this two-day national webinar on intellectual property rights. I gladly welcome the eminent resource persons, Professor M. Venkateshwarlu, Department of Commerce, Sri Venkateshwara University, Tirupati, Dr. Kamaruddin, Assistant Professor, Department of Management and Commerce, Maulana Azad National Urdu University, Hyderabad, Ms. Jyoti M., Lecturer in Commerce, St. Joseph's College for Women, Visakhapatnam, for accepting our invitation to share their rich knowledge and expertise with the teaching fraternity. I congratulate the convener, Dr. G. Sudhakaraya, lecturer in the Department of Commerce, Dr. M. Sambasivudu, the co-convener, and the head of the Department of Commerce, Ms. M. Vanaja, the organizing secretary and the faculty of Commerce Department for organizing two-day national webinar on intellectual property rights. Coming to the topic, intellectual property rights plays a vital role in enhancing the socio-economic prosperity of the country. IPR enhances motivation to disseminate scientific and technological information, which in turn stimulates research and development for the improvement of the quality of life. In India, patent applications can be filed by a patent agent or an individual having some scientific and technical background to understand the invention. Before filing the patent application, inventor must be sure that the subject is eligible for patent protection, the invention has something new, the invention is not obvious and is not easily predictable from the general consensus, and the invention has practical application. Thus, there is a need to create large public awareness about the pivotal role of IPR in the globalized knowledge economy with special reference to patent drafting and its filing procedure. With this view, to create awareness on the significance of IPR and patenting to the people from various sectors in the country, we are organizing this online webinar on intellectual property rights. I wish all the success and implore God's blessings upon all the participators to have fruitful deliberations. Once again, I welcome you all to participate in this webinar and to have very informative and enriching sessions. Thank you.
Thank you, sister, for your opening remarks. Thank you. Let us invite Dr. G. Sudhakaraya, lecturer in commerce and the convener for this two-day national webinar on intellectual property rights, to brief about the significance of this seminar. Welcome, Dr. Sudhakar.
Respected dignitaries and all the participants, I am happy to be present here today in this national webinar on intellectual property rights. Let me extend a hearty welcome to all of you. Intellectual property right is a significant tool in today's era. The risk of an innovation getting infringed without the knowledge of the investor stands very high. With the increase in the importance of IP, instances of IP crimes have become the part of and parcel of this day's era. Sometimes even leading to failure of businesses. Companies rely on adequate protection of their patents, trademarks, and copyrights, while customers make use of IP to ensure that they purchase secure assured goods. An IP asset is like any other physical property offering commercial benefits to the business. In a web-based world, IP protection is much more relevant as it is comparatively simpler than ever to reproduce any specific template, logo, or functionality. Hence, strong IP laws give protection to IP and contribute to the economy of the respective state. Intellectual property right is one of the sources of security for intangible properties which are still open to the public and which can be quickly replicated by anyone. Intellectual property is the result of conversion of knowledge into a commercially exploitable potential. It is for the betterment of all nations that we promote intellectual property rights. Only societies where such rights are protect, witness cultural advancement and economic progress. We need to bring down the concept of intellectual property rights from the ivory tower of legalistic jargon to the common man. Some of the recent developments have made IP a part of common law. Intellectual property rights helps in protecting creation of the mind that include inventions, literary or artistic work, images, symbols, etc. If we create a product, publish a book, or find a new drug, intellectual property rights ensure that you benefit from your work. These rights protect your creation or work from unfair use by others. As for my knowledge, there are two types of intellectual property rights. The first one is copyrights and the second one is industrial property. Copyrights give authors the right to protect their work. Industrial property rights include trademarks, patents, geographical indications, and industrial designs. Intellectual property rights are governed by the World Intellectual Property Organization. World Intellectual Property Organization harmonizes global policy and protects IPR across borders. We as researchers rely on the published work to create a new hypothesis or to support your findings. We should therefore ensure that we do not infringe the copyright of the owner or author of the published work in any way. Teaching and training in intellectual property rights are not issues of law faculty alone. They should span across all subjects: engineering, technology, applied science, economics, management, social sciences, and even literature. After all, intellectual property is found in all branches of human endeavor. Universities are academic communities organically linked with society. Promoting IP education in universities is crucial to promoting in IP society. The future clearly belongs to innovative societies. You as teachers shape destiny of nations in your classrooms. The topics slated for discussion in the 2 days cover a wide spectrum of aspects of IPR teaching. I am sure these discussions and exchange of views will give a boost to teaching of IPRs in developing countries. I also hope that it will lead to more informed decision making at the policy making level. I thank the management, Dr. Shaini KP, the principal of JMJ College for Women, for encouraging the Department of Commerce to organize this 2 days national webinar on intellectual property rights. We have eminent speakers to enlighten us on this topic. As a coordinator for this 2-day national webinar, I invite all of you to participate in this webinar more actively and get benefited. I thank the speakers of today for accepting our invitation to share their knowledge in intellectual property rights. Thank you, one and all.
Thank you, sir, for your presentation. Thank you, sir. It is a great privilege for me to introduce today's keynote speaker, Professor M. Venkateswarlu, Chairman, Board of Studies PG, Sri Venkateswara University, Tirupati. He was born in Prakasam district. He obtained all his MCom, MPhil and PhD degrees from Sri Venkateswara University. He is having 29 years of teaching experience. Under his able guidance, 7 MPhil degrees, 25 PhD degrees and 10 postdoctoral fellowships were awarded. He has published 143 articles in various national and international journals, attended several seminars and webinars as a resource person, and organized several workshops and seminars. He has completed one UGC major research project and one ICSSR project is ongoing. He is a BOS member of Davanagere University and Bangalore North University, and he is editorial board member of Self Journal. He is a life member of All India Commerce Association, All India Accounting Association and Business Vision. At present, he is the Chairman, Board of Studies PG, Sri Venkateswara University, Tirupati. Above all, he was the research director to our convener Dr. Sudhakar, and who got first PhD degree under the guidance of Professor Venkateswarlu. Congratulations both of you, sir. Let us invite Professor Venkateswarlu to take over the session and to give his keynote address. Thank you, sir. Over to sir. Sir, please welcome.
Sir, take over the session, sir.
Sir Venkat sir, unmute చేసుకోండి. Please unmute your audio. Sir, unmute చేసుకోండి. Unmute చేయండి. చేశాం సార్. Sir, once again, good morning to all of you. At the outset, I congratulate my student G. Sudhakaraya, who is
good morning,
organizing. Who is organizing and the convener on intellectual property. I would like to invite the chief patron, Dr. Teresamma Gade, chairperson, Dr. Shaini KP, principal of MJ College, organizing secretary, M. Department of JMJ College, assistant professor, Gayatri Parishad College, for Dr. Karimuddin, assistant professor, Department of Commerce and Management, Maulana Azad National Urdu University, Hyderabad, and head of Department of Commerce, research scholars, and student friends. It gives me great this today.
సార్ మీ వాయిస్ క్లియర్గా రావట్లేదు సార్. ఎక్స్క్యూజ్ మీ సార్ వెంకట్ సార్. సార్ మీ వాయిస్ క్లియర్గా లేదు సార్. ఇంటర్నెట్ ప్రాబ్లం అయి ఉంటుంది, ఒకసారి చెక్ చేసుకోండి సార్. లేదు సార్, అది స్ట్రీమింగ్ సరిగా అవ్వట్లేదు సార్. మీ వీడియో ఆఫ్ చేసుకొని మాట్లాడరా, లేకపోతే అది దానివల్ల ఏమైనా స్ట్రీమింగ్ స్లో అవ్వచ్చు. వీడియో ఆఫ్ చేసుకొని మాట్లాడండి సార్. ఓకే సార్, ఓకే సార్, ఏదైనా ప్రాబ్లం ఉంటే ఇంటిమేట్ చేస్తాను.
Okay. Okay, sir. Though this topic is, I would like to share some of my views on this auspicious occasion. Okay. With the rapid growth and opening up of the economy, intellectual capital has become one of the key wealth drivers in the present international trade. Intellectual property rights have become significantly conspicuous on the legal horizon of India in terms of new statutes and judicial pronouncements. Intellectual property is made up of two dictions. One is intellect and property. These property may be tangible and intangible. Property refers to creation of mind, that is industrial designs for articles and literary works. Product of the intellect that has commercial viability and importance. In other words, intellectual property is a set of principles and rules that regulate acquisition, the use, the enforcement, and the loss of rights and interests in intangible differentiating assets that are vulnerable of being used in commerce. According to Benchman, property and law are born together and die together. And in his perception, property and law cannot be separated. And in so many laws covering various of intellectual property, trademarks, patents, copyrights and related rights, industrial designs, diagrammed designs of integrated circuits, information technology, and cyber crimes. And if you go to the history of Indian patent system, we had pre-independence also, we had a patent system in India. In 1856, the Act 6 1856 on protection of inventions based on the patent law repealed in 1857. The Act modified as Act 15, patent is called exclusive privileges making, selling and using inventions in India and authorizing others to do so for 4 years from date of filing specification. And also, the Patent Act has been amended since 1872 in so many times. And the Patent Amendment Act 2005 came into force from 30th June 2005 to incorporate TRIPS requirements, 4 schedules. That one is prescribes the fees to be paid, specifies the list of forms and the text of various forms required, prescribes form of patent to be issued on grant of the patent, prescribes costs to be awarded in various proceedings for the controller under the Act. If you go to, I would like to the impact of intellectual property rights here. There is intellectual property behind almost every product and service we use in our everyday lives. Intellectual property rights play a crucial role in our daily lives. There is no doubt at all. There is not a product that we encounter every day that has an IP protection. Your morning cup of tea to the air conditioning system at work, or that selfie you take with friends are possible due to intellectual property rights. Some of the important intellectual property rights in different walks of our lives are art and culture. Movie making involves big teams, enormous budgets and undeterred effort. If someone decides to remake a movie in another borrowing ideas the original with impunity, the actual creator revenues. Their hard will also gain its due returns. Similarly, if an author copies parts of his piece from another writer, the latter could lose feeling discourages people from revealing their creations. Copyright comes in handy in the creators are sure that their original work is protected through copyright. They can reap finance encourages them to work together. And with regard to and manufacturing, something as simple as switching a light bulbs has been made possible through patent. Thomas Edison and Joseph Swan came up with the first light bulbs and immediately patented it, which was a crucial factor for their business to develop. The significance of intellectual property rights lies in an encouraging innovation, development of products and services that could make life simpler and letting your business grow. Industrial design. Design plays a vital role in almost every manufactured object we use regularly. A water bottle, your car, refrigerator, shoes, clothing, you name it, and the product is the result of dedicated thought, time, and money. Good product or service will not only be attractive but also ensure functionality. In the early days, car doors had a clunky handle that required some muscle to be operated. Today, car handles need the slightest of tugs, that is called fine tuning design. And with regard to product identification, often we come across marks, symbols, things that convey the purpose of the product. We identify products such as McDonald's, Coca-Cola, Pepsi, Decay, Adidas, Fevicol, Amul, and Britannia through their unique symbols that have become synonymous with our everyday lives. This trademarking is an integral part of patenting of your product. We need to protect intellectual property as IPRs are non-partisan and are embraced in all sectors of society, ranging from labor organizations to trade associations. If you look at the significance of intellectual property rights have a significant influence on economic progress in the sense that to enhance research by disseminating information on advances in technology, promote the innovation process, facilitate the on the technology transfer, encourage high-risk investments which lead to industrialization, avoid duplication of invention, investment in research and development, reduce cost of production. Once a country installs a solid and effective intellectual property system, the access to more advanced technologies increases. Technology transfers, licensing and investments become much easier with IPRs as vehicles or bases. Import of technology leads not only to export of products but also to export of adapted, improved technology. We can say reverse technology transfer. Acquired technology generally comes accompanied by foreign capital and investment in considerable quantities. Patent claims allow to define precisely the technical and territorial scope of any technology to be transferred, provides inventor several ways in commercializing inventions. First, to start their own manufacturing and marketing of the product based on invention, to license the rights of the invention, to sell the patent rights. Intellectual property rights acknowledges and gives official recognition to the efforts employed by the person or organizations, promotes further and research endeavors, creates and helps in combating against piracy, unauthorized copying and plagiarism, unfair trade tactics and competition, encroachment over traditional knowledge, serves as a basis of monetary and fringe benefits to the inventor. And why these intellectual property rights could be protected. These intellectual property rights could be protected with regard to performances, broadcast, videos, computer games, computer programs, images, logos, trade, marks, integrated circuits, inventions, geographical indication, companies' names, industrial processes, chemical formulas, methods, perfumes, and the like, and so on. And also, the intellectual property rights are also facing so many challenges nowadays. There are many intellectual property rights that one faces while getting IP rights in India. The issues are as patent evergreening prevention. One of the most important intellectual property rights issues challenges is the prevention of the evergreening of the patents for multinational companies. Evergreening is a strategy for extending the term of granted patent which is about to expire without increasing therapeutic efficacy in order to retain royalties. As we know, the companies cannot evergreen their patents simply by making minor changes. So, Section 3D in the Indian Patent Act poses as one of the biggest issues with regard to IPR. This act bars the grant of patents to new forms of substances. This has discouraged investment from Western countries. And the second challenge the IPR faces is that subsidies and IPR issues. Major forms of subsidies includes food subsidy, fertilizer subsidy, education subsidy, and etc. For the complete implementation TRIPS agreements, one need to reduce or eliminate these subsidies. The government of India needs to create a balance between providing subsidies and providing IP rights in India. The product patent process. The product patent protects the it offers high protection to the original, reduce the competition for the same product. Whereas a process patent protects the process through which one manufactures the product and not the product. The element of monopoly in the market. As India is part of the agreement, all its members to shift regime from process to product patent. This remains a challenge for India. Process patent would be more helpful to a country like India. This is since India is a developing country, our ordinary people are struggling with the basic protecting traditional knowledge. Traditional knowledge, especially in the field of medicine, is like Government of India is bound to protect knowledge by not allowing multinational companies to get patent on traditional culture. Above all, the government has created a traditional knowledge digital library to prevent the patenting of traditional knowledge. So, this is one of the intellectual property rights issues in India. This is one of the major challenges facing in India. One of the most important intellectual property rights issues that the government needs to address is the use of compulsory licensing. Compulsory licenses are authorizations given to a third party by the government to make use or sell a particular patented product without the need of the permission of the patent owner. The provisions regarding compulsory licenses are given in Patents Act 1970 and in the TRIPS, trade-related aspects of intellectual property rights agreement. It is a relaxation available to the developing countries under the TRIPS agreement, something which organizations misuse sometimes. Moreover, under Section 84 of the IPA, a company can acquire a compulsory license for private commercial use under certain circumstances. With the drug price control order, the company needs to justify the price of the drug with regards to if someone plays foul, then the government has the right to intervene. Multinational are asking the government this provision. However, government of India is not conceding the demands to protect the interests of the masses. There are also some other issues which should be discussed in the national webinar in 2 days. That is trademark violations India. India has a very high level of trademark counterfeiting against which the authorities in India do not take proper actions. Enforcement of IPR regulations is quite weak in the country because of two important reasons. India is the exporter of counterfeit fake products, subs, textiles, shoes, electronics, etc. Judicial delay in IPR disputes. India maintains a high custom duties on intellectual property intensive products as advocated by Western countries, impacting the investment. So these challenges should be addressed properly, then only the IPR may be protected. Sir, with this, I would like to conclude my speech, and I am very happy to participate this seminar because my students, Dr. Sudhakaraya, Dr. Sandhu Sivudu, being the part of this webinar, I wish this webinar would become this, and also I am very much thankful to the college management who has given me this opportunity. Thank you one and all. Thank you very much for participation. Thank you very much. Sudhakar?
Sir.
My speech is over.
Okay, thank you, sir.
Thank you, sir, for your valuable and elaborative keynote address regarding intellectual property rights. Thanks again, sir.
Thank you. Thank you very much.
Now I invite Dr. G. Sudhakar, lecturer in Commerce, JMJ College for Women Autonomous Tenali, to introduce Mrs. M. Jyoti, who is going to present on trade secrets and patents in this second session.
Thank you, madam. I feel happy to introduce resource person, Ms. Jyoti Medapati, Assistant Professor, Gayatri Vidya Parishad College, Visakhapatnam. Ms. Jyoti has worked in St. Joseph College for Women, Autonomous, Visakhapatnam since June 2012. She secured first place in SSC at school level and secured sixth place at state level in her intermediate education. She has completed her MCom from Andhra University, MBA from Dr. L. Bullayya PG College. She has qualified Andhra Pradesh State Eligibility Test 2021 in the subject of Commerce and Andhra Pradesh State Eligibility Test in 2018 in the subject of Management, and now currently pursuing PhD in Andhra University. She has participated in many national webinars, faculty development programs, workshops, and conferences, and also published papers in reputed journals. Though very young, but she has vast knowledge in most of the areas. We are happy to have you as today's resource person for this webinar. Hearty and warm welcome to you, Madam Jyoti Madam. Thank you, Madam.
Thank you, sir. Thank you so much. That is a very warm introduction about me. And before I begin the session, I once again welcome you all for this two-day webinar. And a special thanks to the principal, organizing committee members, and especially to the Department of Commerce who have been so obliging, uh, who have been chosen me as a resource person, and I'm very much privileged about it. And sir, thank you for the valuable input, sir. Venkateshwar, sir.
మేడం మీ
It is
ఆడియో క్లియర్గా లేదు మేడం.
on
Jyoti,
IPR,
madam.
which made my work a bit easier because my streamline of discussion will be completely on
జ్యోతి మేడం, ఎక్స్క్యూజ్ మీ
trade
మేడం.
secrets. Since student of business administration, I would like to focus
Excuse me,
entirely
madam.
on trade
Jyoti,
secrets,
madam.
right? So before I move to the session, I would like to present my PPT.
జ్యోతి మేడం,
Yes. Sir, I didn't get you. Yes, sir. Sir, I would like to present my.
So I hope now I am audible to you all. I request the organizers to please kindly display the PPT search because I have disconnected through my laptop because of signal issue. So that I will feel free to share the PPT and we can run the slides and we can proceed with our discussion. May I? Okay. Thank you, sir. Thank you for presenting it. So I'll turn off my video such that it will help us a lot in making our discussion very smooth. Yes, sir. You can please go to the slide. That is, we are giving a talk on intellectual property rights. My special concern is on trade secrets. Since I'm a person from Business Administration Department, my key areas were on elucidating facts about business. And so here, coming to the first one, what a trade secret is. To define with a trade secret by NAFTA, which is North American Free Trade Agreement, it is a piece of information which holds a commercial value, which is not in public domain and for which reasonable steps or measures have been taken to maintain its secrecy. So the definition goes very crisp in a very short and sweet manner, right? It is some information which holds in any economic value and it is not at all disclosed to the public. And why such discussions, why we have to retain, why we have to refrain it from the public domain is because it should definitely make a sense of economy to the organization who is holding or who is trying to maintain that secrecy. Coming to the next slide, which we talk about the other definition of intellectual. Sir, you can please go through the second slide. So please go to second slide. I mean third slide. Third. Okay. This is another definition which is given by TRIPS, that is trade related aspects of intellectual property rights. They lay special focus on basic three essential conditions, which include maintenance of secrecy. That means you should not encourage people to get access to your information. Once the information is easily accessible, once the information is easily available for public, it no more remains a secret. Of course, all of us are aware of the word secret, right? Secret is not something which you tell to everybody. Secret is something which is confined to only your closest circle. Now, the same when you interpret it with business terms, when you talk about business secrets, when you talk about corporate secrets, they are some crucial information which is only circulated among their comfortable groups or among groups in which they are operating, right? And why we do this? Obviously, because we have some benefit out of it. We can generate some economies out of it by maintaining the secrecy. It derives commercial value in case it is patented or in case it is licensed, right? So trade secret remains a secret only if you keep it secret. Once you want to disclose it, once you want to bring it into public notice, or once it is displayed, or once the secrecy is disclosed, then it is no more a secret. It is considered as a trade secret. Now, coming to the next slide.
ఏమైంది రావట్లేదు మురళి రావట్లేదు
Sudhakar sir, please. Sudhakar sir, please. Can you just go to the next slide? The next slide includes the trade secrets. Now, what can we call them as trade secrets? By the way, I want to keep my presentation very crisp and short. So my area of focus was only on the scope of this discussion. Will only talk about how you define a trade secret. Why do you call it as a trade secret? What is the important emphasis on a trade secret? And how can you protect it? The reason behind why I want to present this, at a glance, all of you are now aware about what is IPR, that is intellectual property rights, which includes patents, copyrights, trademarks, and whatnot, right? This trade secret has become nowadays very phenomenal because when you talk about patent or any other IPR, it is disclosed. It is into the public domain, provided there is some restriction on how you can put into use. But when you talk about a trade secret, this is completely a business phenomena, completely a commercial strategy, which we call, right, and which they do not want to others to copy it, or they don't want others to duplicate the information. So this trade secrets can include a formula, any sort of, I'm not talking about the mathematical formula, by the way, I hope all of you are aware of it. It could be a chemical formula, a reaction, or any best practices that you are indulged in, right? It could also include a product, a design, or some instruments which you are using to bring the output, or some patents, and any commercial methods that which you are adopting within your reasonable framework, right? Coming to the next slide. Next slide, please. Yeah. Now, as a tool, trade secrets can include any of it. It could be a formula, it could be what do you say? It could be a practice, it could be a design instrument, right? That means you should hold a key in retaining them. You should try to hold them. You should try to maintain secrecy only to the people or area of your interest. That means only people concerned with that. Maybe the making process you can call. So you can please go to fifth slide. I'm still in fifth slide. Please go to the fifth slide. I don't want the second slide. Yeah, thank you. I will inform you of the next and then you can go. Okay, right. So once a trade secret is opened up, it is made easily accessible for the users. It will no more remain a trade secret, and you don't develop any commercial value on it. And let me also tell you, trade secrets are not something away from intellectual property. They are a part of intellectual property. They go in par with intellectual property. But there is a fine line of distinction. When you carefully look into patents, trademarks, and trade secret, a fine line of a distinction can be easily drawn from comparatively from all the three, right? Now, when I say about a trade secret, it is remaining a secret. It could be a process, it could be a method, it could be a technology, whatever I'm using, methodology, practices, processes, whatever it is. It could be a secret. But when I have to get a patent on it, the information has to be disclosed to the officials. And the information has to be presented. The information has users such that they either make a better version of it, or it becomes easier for people to copy it, or to duplicate it, or to invent related kind of products, right? I think already sir told so much about the patents also, right? So I don't think I have to brush up so much. But once you want it to be a patent, you have to disclose the information. But seriously understand, there's a lot of business or commercial agencies or the corporates who don't want to disclose their practices or methodologies. That is one way, even though they don't derive any commercial advantage, even though they don't get competitive advantage. What is a competitive advantage, by the way? Where you can gain more attention over your product. There's a lot of charisma going towards your product, of goodwill running behind your product. Oh, what is the secrecy? Why people are not disclosing? So some kind of, what do you say, some kind of enthusiasm you can create when the trade secrets are not disclosed. But once it is patented, there are enough number of competitors who can come or merge with your company, copy the product, they can make a better version of the product. So most people do not wanted to keep it in the public domain. They do not want it to be disclosed because they the product, and hence they wanted to keep it only as a secret. Over it.
Excuse me, madam.
Yeah, thank you. So here we have few examples, which the sixth and seventh slides I have paired are four famous examples that we all know. All of us know Coca-Cola, right? Coca-Cola has not even revealed its trade secret till now. The formula is only with two people. It's surprising, right? But it is very true. The formula vests is only two people, and this formula is carefully preserved in a city called Atlanta. None of us can go check, observe, get the information. They remained it so secret, right? Only the legal hires of that Coca-Cola company or the legal hires of that Coca-Cola founders only will be revealing the secrets to the next generations, but no other people are aware of it. There have been enough of drinks in the name of making of Coca-Cola. There have been, but no, none of things can be matched to Coca-Cola. Yes, of course, Coca-Cola has been running with a negative reputation in you saying that in use of pesticides and other thing. They all got those clearances, but the formula, the making of it, how the product is formed, none of us know. And second interesting element is your KFC. I hope all of us are mad about KFCs, right? By the way, I'm not so much mad, right? If just it's KFC has, when it is launched, it has a special element which is called as talking about 11 herbs and spices. The kind of spices they use, the kind of toppings they use are never revealed, right? And there are only few people, the makers or the people who make the product. There are few people, very fewest people who have a knowledge about the product combinations, who have knowledge about how the process is made out and how the blend of mixtures are added together. And none of the people outside KFC have complete knowledge about this great recipe. Now coming to the next slide. So please go to 7th slide. Here are two more examples we have. That is crispy creamy donuts. This Krispy Kreme donuts are also maintaining a trade secret for 70 years. This, if you just look at this example, it is phenomenal, right? Because you can't expect a trade secret for over a period of 70 years. There are a lot of donut companies which has come, but how the making it is, how the recipe was made, and how actual recipe was made, none of us have known. So there is a process called as reverse engineering. I think almost most of the technical people would know about it. When you talk about reverse engineering, you bring the product, you open it, you go deeper into it, check what ingredients are put into it, and then you can try a lot of permutations and combinations can be tried. But there is no essentiality that it brings the cream of it. There is no essentiality that it will give you the same kind of content, right? So these, by the way, this Krispy Kreme donuts has really no commercial value, but still they still, as a legacy, they are continuing to keep the secret from outsiders. They don't have any competitor because there is a lot of dominating other snacks have come into it. There's a lot of other donuts also have been available in the market, but the real secret is still not known to it. They just wanted to maintain that secrecy. And in my examples, I have here last but not the least, which we call it as Google. This, I don't have to talk so much about it because almost all of us are pretty aware of it, right? Now, when I'm talking about this Google search algorithm, people are cracking heads to reveal out what the Google secret search algorithm is, but Google has kept it as a business secret. It gives them commercial advantage over the other people. It gives them a lot of competitive advantage, but still, Google always wanted to keep this as a secret. And so, next slide. Yeah, thank you. Now, why are we talking so much? The trade secret is a secret. You don't want to reveal it? Fine. No. A trade secret carries a lot of advantage. As in the beginning of definition, we have been discussing about how it can gain a commercial advantage, right? See, it involves no cost. When you talk about a patent, when you talk about a patent, there is
ఫోన్ చేసి చెప్పు.
can also
అదే
to
మనకి తెలిసిపోతుంది.
and to the people around me. Right? I want it, right? I don't have to apply for it. The only thing is, it has to be documented. This is a bullet point to be noted. It has to be documented. There should be a legal agreement, a bond, bond agreements have to be made such that the secrecy is maintained within the known groups only, right? And there's a lot of in the next coming slides we're going to talk about misuse of these trade secrets, how it is going also. So I don't have to apply for it. I don't have to wait for it to get it registered. It does not involve any extra cost. If you know about a procedure, if you are inventing something, even at your college level, you have some inventions, you can happily go to it. So please continue with 8th slide only. I'm still on the advantages. You can happily go and make a trade secret, and you don't involve any cost except the only cost which includes administrative cost and technical. Administrative cost in sense the documenting, maintaining its secrecy, and when you talk about technical cost, where you preserve it and how you safeguard your trade secret, because once it is documented also, there is a chance of being there is a chance of losing it because of theft or any other misappropriation, or the person himself reveals the secret. So some sort of technical cost will be, but compared with patent, it is very, very minor. And you don't have to apply, and you don't have to get any permissions from outside authorities. It is completely maintained at your business hierarchy. Now coming to the second advantage, it does not require disclosure. When you talk about the patent, even if I'm not interested, I have to disclose the fact, how it is made, what is the procedure, the basic making of it, the basic procedure involved in making the product, what all products are used, everything is disclosed to the authorities, and it was under public domain. But when you talk about a trade secret, I don't have to reveal it. It's my business secret. So it will give a lot of advantage, a commercial advantage when I'm advertising, because you are raising the enthusiasm in public. You are trying to keep it more secret, more confidential, and more itself, it's only centered to the people. So people would like to be in that organization and they don't want to get the information outside. And that is how you retain your employees too. Anyway, retention of employees is also important factor. Here we have to consider it. Okay, that is one more advantage where employees will be treated fairly because their secrets may not be revealed outside. And important element is no time limit. If you talk about the patent, see, my discussion was mostly going on comparative patents and trade secrets. Even though my concept related only to trade secret, a comparative analysis will always help us understand much better what a trade secret is. So there is no time frame for patents. You have a time limit for over 20 years. Once 20 years, everybody is free to use your product. So you can't hold, just like in the sake of example, when we are taking the donut, the creamy donuts, when we are talking about that, it has retained its trade secret for 70 years and above. Is it possible? Coca-Cola, I have seen since my childhood. It is almost decades and decades of years, right? They still continue to everybody advantage you have, right? And coming to the last is immediate effect. In case if I want to apply for a patent, I have to get it registered, show the procedures, acceptance should be made, and I also have to talk about if did I sort of manipulation under my inventions. So I have to get a clearance certificate. So this of procedural headache to get a patent. But when you keep it as a trade, right, you don't go with the patent, you can let it have a secret for yourself. I mean, of course, trade secret, yet it should hold a page for you. And it is useful. So next slide, please. Here we're going to talk about the laws related to trade secrets. Of course, let me clear one thing to you all. Trade secrets are usually the highest capacity at which a business can maintain its secrets is the highest authority as how you can retain your information. In case you need protection, in case you need support by law, there is few authorizations and how you can get law. Okay, other than that, it is the business who should look in. It's the what do you say? How you can eliminate that kind of disclosure of information, right? Now, coming to the law on trade secrets, any unauthorized use of these trade secrets by any other person other than the holders of the information is considered as an unfair trade practice, right? If it is not yours, you have no right to use it. In case you're using my trade secret through any other means, then I will surely mark it as an unfair trade practice, and I can go to court for suing the person, and the plaintiff can be questioned on this, and you can get a reasonable advantage of it. Sometimes once you are able to prove that this is your invention and you kept it as a secret, and the other person has manipulated, or he has gone for theft or any other way, when you can prove to the court of law, you can also in cash back. Okay, or can also get money rewards for it, because you are able to prove the other person that he has copied your trade secrets, or his unfair means to get your trade secrets, and he has used it in his invention. And there is a choice also that you can stop the other person's process. Products will not be sold in the market, and what all technical loss that you have suffered in this regard can also be reversed by the other party. Now, coming to the other important segment of this trade secrets protection under law is it is protected based on your contract law, principle of tort, criminal law, and specific trade secret. What is contract law? So next slide, please. Next slide. Thank you. Now, when you talk about a contract law, almost all of us are aware of it. The contract law includes a contract which is established between parties, right? And they have a contractual option saying that to what extent they are authorized their information and to what extent they are supposed to maintain confidentiality, and they are indulged in a contractual relationship, right? So, under contract law, if you look into a deeper grounds of it, the two main elements which I focused here is a contract law should sustain a confidential relationship. It should help in retaining confidentiality, and the agreement is main attributed. In the in how our and its
Excuse me,
front
madam.
misappropriation, it can be also considered as unfair
Excuse me,
means,
madam.
and since they don't have is there any problem?
Phone చేయండి.
Obligation when there is no contractual relationship, when there is no formal
చెయ్యము.
contract between, then automatically it can be considered as misappropriation, and that is one example. Treated as the best example for this. So next slide, please.
Chat box లో రాయి.
Am I audible? Can we go to the next slide? That is criminal law and specific trade secrets law. Yeah. Next one. Yeah, thank you, sir. Now, when you talk about a criminal law, right, this is something which we see most of the cyber crimes and all, right? So when you talk about, because nowadays lots and lots of information is through e-format, lot of information because of accommodating space, or because we want to have a greater advantage of it for the next coming future, or because we wanted to preserve this information for making it easily accessible, because when you put it in documented form and other things, it may not sustain for a long time. So most of the time huge business organizations are encouraging this e-format based form of retaining their agreements, right? Everything is e-agreement. Now we're learning so much of e-commerce and e-trading, right? So most of the trade agreements or contractual agreements are made in e-format. And there is a lot of theft in this regard. Why? Because most of your e-formats or most of uh, these e-kind of content is being under unauthorized access. Like most of the cyber crimes that you can see offer in news, a lot of cyber crimes, cyber thefts are going on, a lot of confidential information is being hacked by different people in the organization. That will again be a immense problem to the company. So in case if any unauthorized access was noticed, this can be seriously reported to the law and legal actions will be taken. So that is one way you can also protect. But the only thing is, once an information is disclosed and misused, we have nothing to do. So the only thing is we can file returns, we can file a complaint on the person, get a reward, get the compensation from the other person because of his unfair trade practices, or you can ask him to stop his making. Only to that extent you are limited, but your secrets will be out, right? So here are few more trade secret laws. That is, we have Uniform Trade Secret Law 1985, the procedures, policies included in that also can help us in saving our trade secrets. Coming to the next slide. Coming to the next slide. Okay. Right. Now, what this is my real emphasis was on not just legal protection is alone sufficient. It is the duty of the organization to take a reasonable effort. The reasonable measures have to be taken by the organization to protect your assets. Now, when I'm saying it is an asset, please don't ask me. It will not be displayed on the asset side of the balance sheet, unfortunately, because they are kept as secrets, right? But it will definitely give a commercial advantage. It will definitely give a competitive advantage. So we consider them as an assets, right? So yes, these trade secrets work as an assets to the organization, and it will be whole and sole duty of the organization to protect them. And when you're talking about the legal protection, just give me a second.
Next slide.
Thank you. And when you're talking about the administrative measures and technical measures that which we organized or operated organization level, the administrative measures include robust secret policy. That means a rigid, strict policies. Depending upon the organizational policies, how you can, depending upon the organization policies, is how you can monitor, as you can control the element of secrecy. That means the lesser people around you, the greater is the efficiency of maintaining secrecy. The more involved, the more people are involved, the greater is the scope of knowing. So, if you want to keep a trade secret for a longer period of time, it is always advisable to limit the number of people who have access to the trade secrets. See, because most of the organization policies will be confined only at the administrative level. The subordinates are majorly not aware of what is actually happening. This is only the purpose because they wanted to keep these things as secret. Okay, so you should give an orientation. You should promote your employees. You should cultivate the habit in your employees that our organization has a strict policy, and we cannot share information, or you cannot disclose information to others. And if you are disclosing information, these are the legal bindings that will be applied on you. So such kind of induction or orientation can be given to the employees, such that the trade secrecy can be maintained to the greater extent. Okay, so the policies, procedures, rigid rules, and see that the information is passed only to the people who are under the operating circle, not to everybody. Coming to the next slide, which includes technical measures. So can you please go to next slide? Technical measures include the security measures. The security measures, as I told you, most of the trade secrets are in electronic form. Most of the trade secrets are in electronic form, and hence it will become so difficult for organizations to continue or to keep that electronic format, right? So technicality, that means developing software, using software which is of good worth, using software which can create less access to outsiders, which cannot be easily hacked. So sometimes large organizations, prestigious organizations should invest on good software, on good technicalities, people around them, technical qualified people who can refrain the information only within there to the outsiders. Okay, and this way how we can avoid lot of cyber securities. Sir, can we go with the next slide? Okay. Now coming to the last and important content of discussion is that as trade secrets are something which has to be within the confidentiality, as trade secrets have to be within the reasonable number of members, such that we cannot encourage others to join. We will not, what do you say, we don't have to bother. It's only, okay, it's involved in the procedures, only will be there. Others don't have access to it, others are not informed about it, and others are not aware of it. Okay, but there is lot of chances where lot of information can be copied, because keeping it for minimum number of years is highly possible. But when you talk about large number of years, when you wanted to keep your content for a larger period of time, it will be very difficult. At this juncture, let me talk about the example of Coca-Cola. There are some interesting facts about Coca-Cola. You can also Google search and find these facts. Some facts include the Coca-Cola founders, only 2 of them are aware of the formula. You know that? Only 2 of them. This will be passed to the legal hires in the next coming years. But officially it was not disclosed that the legal hires were aware of the information. And you know something, these two founders are not allowed to travel in the same chartered flight. They are not supposed to have the same food which is offered, because if the food is contaminated, the food is poisoned, both of the founders will drop Coca-Cola, and then there will be no space for Coca-Cola. If something happens when they travel by flight, at least one founder should be available to pass it as a legal to the legal hires, the formula, right? So most of the Coca-Cola founders, they're not allowed to go through the same charter flight. They're not allowed to have the same food. See, that is how I'm talking about the policies which company can indulge in. So you have to be relevantly good in how you define your trade policies or how you make your policies and procedures of the organization, right? It is not all the time about stimulating an employee to be so much loyal to the organization. You should also limit the access to the employees, and at this juncture, I would like to quote an extra feature. Retention of employees by the organization seems to be one of the greatest way of retain choices. When you retain employees, when they are made comfortable to work in an organization, most of the employees will not step into other organizations. And once you step into other organizations, there is a problem. There is a tendency of sharing some important information to the other. So that is how the information can be diluted and it can be surpassed to the next people, right? So retention of employees can also help employees to become more loyal, and they would obviously cooperate with the policies and procedures of the organization with no advantage of economical elements. Okay. Now, and what is this clean room is? The clean room is because, as I told you, trade secrets are only documented based on some contractual agreements. You just make a contractual agreement that so in a particular invention, so in a particular procedure, policy, pattern, design, whatever element that we have discussed under the inclusions of trade secret, that we formulate. So clean room is there, the constitutions of people. How many people are constituted, or how many people are available, or how many people are involved in making that design, or how many people are involved in making that procedure, or your team of engineers, or your team of, or your research team you can call, or the designer team we can call, or the engineers we can call, who is involved in making and producing that particular product, and who is clearly aware of it. So clean room is where outsiders, other than the makers, other than the observers of the information, nobody else is allowed to be in that clean room. That means this is the highest element of maintaining secrecy. That means information is within your confidential platforms only. The information is within your confidential limits. No others have an access to use this. And having this kind of element in every organization can eliminate the chances of theft, can eliminate the chances of sharing information in an unauthorized way, and the people involved in clean room will be alerted that others are not aware of the information, and this can be also documented. And finally, this can act as a evidence for proving that it is your trade secret. Because under any chances, see, for example, sometimes you make a recipe, I'll also make a recipe. If the elements match together, because that is my innovation, this is your innovation, right? So there is a lot of chances that trade secrets or procedures and policies can be similar. Under your own personal prejudices, it can be similar, right? So you cannot claim it is your trade secret. So the ultimate percentage of accuracy can be maintained when these trade secrets are confined in your clean room, right? Such that information can be more secure, and information will not be under pilferage, information will be more evidential, and information can be can give more economic value. Having said this, I would like to conclude my presentation. I would seek questions, if any. I'll be happy to answer the questions. And before I close my presentation, I thank all the organizers and the audience for your patience listening and for uninterrupted listening. I also pardon if there are any technical glitches from either of your sides. I kept my content very limited to the crisp form of trade secrets. I hope the PPT is already shared. You can take an advantage of it. Any questions now? Ma'am, if there are no questions, I think we can conclude the session.
Okay, ma'am. Okay. even though some technical problems are there. Thank you, madam, for your excellent presentation on trade secrets and patents. The definition, contents of trade secrets, difference between confidential information and trade secrets, competitive advantages of these trademarks and patents with examples, laws on trade secrets, measures taken by the management of organizations, legal and administrative measures, technical measures like cyber security, and lastly the clean room strategy, etc. Madam, thank you for your excellent presentation.
Thank you, ma'am, for the opportunity.
Let us close the session and we will meet tomorrow by 10:30 a.m. sharp. Thank you, one and all. Thank you for your patient listening. Thank you. లేవు, ఎవరు అడగలేదు. అడిగారా? అడగలా ఎవరు. ఆమె చెప్పింది అడగట్లేదు, క్లోజ్ చేద్దామని. మేడమే చెప్పారు. ఆమెనే అంది కదా, ఎవరు లేరు కదా. అసలు టెక్నికల్ ప్రాబ్లం ఆవిడ దగ్గరే ఉంది. నేను అనుకోవటం క్లోజ్ కానీ ప్రతి చోట నెట్ అట్లనే రాదు. బిఎస్ఎన్ఎల్ అస్సలు రాదు.